law be say under Nigerian law a judge or court no get the power to alter, vary or review his own final judgment. That are the ordinary rule. Say a court no get the power to review or vary his own final judgment. But however, exception dey. Once the court don't deliver that judgment, it become what we call functus officios. Another Latin mazin don't come again, but we don't talk for a Latin mazin class. If you don't know, you go back to that class, go learn. Say it becomes the function, the official function for the matter don't end. So that means it no go fit do anything again. But however, exception dey for this matter. But maybe first look why court no fit go back, go review or vary in judgment. Make we first look why it be like that and why the position be like that. Because a judge no fit reverse themselves simply because they realize say they make mistake regarding the evaluation of the evidence for the matter. No, because if you allow them, that means say any judge when give decision finish now, if you go back, go talk, say, oh, I make mistake, oh, so because of that, make we go change. So if a party they dissatisfied with the actual legal reasoning, the only lawful thing what that person is supposed to do now to appeal to a higher court. Than our position, than the law for Nigeria. Once a party, you see higher court, the judges they plenty. Unlike the high court, now one judge. But when it go up, you will get more judges so that many people will feel reason the matter. So that's why courts ordinarily a judge no fit overrule, reverse or sit on appeal over a judgment when he don't deliver, or a judgment when another court don't deliver. A court when they of equal rank, we say equal rank, court of coordinate jurisdiction. Now what would they call a coordinate? The day of equal rank. So one court no fit give order, the other one will say no, I want vary more. Or you go come give your all judgment, you go say okay, now you want to see how you go take vary that judgment or add, except to just make correct clerical errors for that judgment. That now our general rule. And most times, like when they talk, say the law now waiting the court talk say be, and so that is why with the side cases you say in the case of Christopher Ogidi and Mobike Okoli and others, the court of appeal talk say the 1999 constitution only provide for section 241 and 242 for appeal to court from decisions of the high court. So the constitution I talk say once matter don't decide for lower court, the next place now higher court, you no suppose go back to that same court. And so that is why this court of appeal for this matter talks say it is glaring that the trial courts lack the jurisdiction to reopen and reconsider the issues whether it had jurisdiction to entertain the suit pertaining to land in a rural area and it had become functus officios. So when the court of appeal they talk be say when this court, when the lower court for this matter go back, go they reopen the case after they don't give judgment, so they determine whether they get jurisdiction, say that one you don't pass on a power, una don't suppose do like that. So that are waiting the court of appeal talk for this case of Christopher Ogidi and others and Mobike Okoli. So but like we talked just now, we saw say exception day for this rule. So what will be the exception? Which exception will be the exception when court go fit set aside in own judgment? So make we look, say like we talk, however, a court retain inherent jurisdiction to reverse or set aside his own decision as debito justitiae, another Latin mazis, as debito justitiae in the interest of justice, and the court don't lay down the specific legal exception when you go fit, when court go fit, take such decision. And this court where they talk so now the highest court of the land, the Supreme Court of the land, now they talk this also. And so like when they ask for here, be say Omotosho show me the law. What did the law talk? Oshoma, Professor Oshoma, show me the law. What does the law say? What did the law talk? So the law, 1999 constitution, Supreme Court judgment, and all of that. So waiting the talk. Make we open the book, peel the yam small, make we know what our law talk. The locus classicus, when we say locus classicus, another Latin mazin. If you follow our Latin mazin class, all these things go easy for you. So for the case of Stanbic IBTC and LGC Limited, the Supreme Court detail the ground when a court fit reverse itself. The Supreme Court details strict ground. The Supreme Court, for that matter, talks say the court of record, including the Supreme Court, get power to set aside its own judgment given in any proceeding in which there must have been fundamental defect, such as one which goes to the issue of jurisdiction of the court. So if the matter where you decide go to the jurisdiction, the power of the court to even hear the matter at all is a fundamental defect, the Supreme Court say even the Supreme Court gets power to set aside its own judgment, and where the talk we will know. So that is why the court say any applicant, anybody, when an applicant, that's the person where they give that judgment against, when you believe say the judgment affect you, you feel bring an application on the ground of non-service, fraud, and lack of jurisdiction. Say these processes when they file, so say they no serve you the process, non-service. Say na fraud, they do mago get this order, and then the court no get jurisdiction, because normally we say na service they confer jurisdiction on the court. So when you serve process, you must hear the other side. So in the same way, if you know call the other person, can't hear the other side, how court go take talk say they hear the other side? That means no jurisdiction to hear the matter be that. So those now that's in that case, the person when they give that order against go come now say court abeg go, I never see the paper, so we wanna take give this order. Ejo Emma Binu make una let me reverse una self, because make una also hear my side. So like I said, you go agree with me, say at least it make common sense. Say a court will make an order, and when it be say no get jurisdiction to make, say also get the power to rescind the order, to restore the status quo. Now status quo position where they did before they make the order. And also the Supreme Court decided for Akin Bobola and facing fiscal. That's also all this time what is Supreme Court talk. So in such a case, when the defendant proves non-service on him, the whole proceedings becomes a nullity, and the trial court has jurisdiction to set aside the order. So when the what they call them, the defendant don't talk say or the case the applicant now talk say I never see the paper, they no serve me. So you know say since you know hear my side of the case, so that means everything where the court don't do, the Supreme Court say becomes a nullity. So also you will see the case of Skeg Consult, ACS, PLC, and Losada Nigeria Limited. All these are cases where Supreme Court don't talk all these things. So these are some of the cases where the Supreme Court don't talk all of these things. Say so these are the ground where you will fit take reverse, a judge feel reverse itself. And so if such a judgment is a nullity, a person affected by it therefore is entitled as debitu justitiae, in the interest of justice, to have it set aside. Like I don't talk. Say if the judgment day is a nullity because they don't hear you, definitely the person will give the order. If you look say I suppose listen to her, not listen to her, you get the power to say okay, oh yeah, make we reverse am, so that we go hear am. In this case also, the court on the own suo motu, another Latin mazin we don't talk about for class before, on the own fit talk say, you know, make I set that aside once this information don't come, when you find out say they no serve, or the person fit bring an application by motion to set them aside. See the case of Adaigbe and Kusimo. All these are cases where, and Ezeokafo and Ezeko, all these are the cases where the Supreme Court don't decide, talk all these things when they talk. So like they always talk, the law now wait till the court talk say e be, now the law be. So also in the case of Barrister Okike, Jeff, and others against Iyotom in 2015, the Supreme Court come in establishing all those powers where court fit set aside in judgment. the court come set down some laid down guideline when the court suppose look to take set aside. The court come talk say the Supreme Court itself get power like every other court to set aside their own judgment on the following terms. Under the following terms, I can't list the terms for us. So those for that case. So now those terms now will come look say okay. One, where the judgment is obtained by fraud or deceit in the court, or one or more of the parties, such as a judgment can be impeached or set aside by means of an action which may be brought without leave. So in this case now, the court talks say where that judgment they obtain am by fraud, they lie to court, they do mago, they do this thing, chwa. Say, and then the court come find out, say, oh, they do chwa. The court on its own fit say, oh yeah, set them aside, even without asking for leave of court. Or in the case where we say the judgment is a nullity, such as when the court itself was not competent and a person affected by an order of the court, which can properly be described as a nullity, is entitled as debito justicia again to set this aside. So here now I say when the judgment itself is a nullity, when the court itself was not competent. For example, the court, now 3 people supposed to sit, now 1 person I sit. That means say the court is not competent. The court not be properly constituted. So in that case, if you say that order, I beg you, make una set them aside. That now 2. The third one be say where it dey obvious say the court was misled into giving a judgment under a mistaken belief that the parties have consented to it. Where they obvious say the court, they lie to the court, say they agree, we don't settle, we don't agree, but the court can find out say true, these people no agree. Or where the judgment was given without jurisdiction, like the one when I explained, say they don't serve the process, or the court no even get jurisdiction in the first place. Magistrate court, you can't matter go magistrate court, and the morning when magistrate court supposed to decide, it don't pass that decision, and the court just give judgment without jurisdiction. When the court can't find out, the court will say, no, we don't get jurisdiction. Or where the procedure adopted is such as deprive the decision of the judgment of the character of legitimate adjudication. So this one say, like now, the procedure where the court adopts, they don't hear the other side. So if you look at it, you will say, no, the way that this matter take go. You suppose hear both sides now. So it deprive the court or the judgment of a character of a legitimate adjudication. Say both parties, I talk my own, you talk your own. So for that one, the court no even look, say the only one person I just talk. So I think they follow me for the class. So because when I don't explain it like this now, we will now go to the judgment of the NDC, the local judgment. Come apply all of this principle to that judgment, so that they try lay the foundation first, so that you self go understand what we mean. And then the Supreme Court also not just leave and there, they can't go further. They can't say if you they consider all of those steps when I don't list for you, so when you consider them, you get some small things where you will look like the character of the person when they bring the application. When you bring the application, if you grant this application, it will affect the other person, all of those things. So the Supreme Court in Williams and Hope Rising voluntarily formed now also actually laid down the condition for setting aside a default judgment as follows. Default judgment is okay, now only one party you hear, so you know to hear the other side. The party when the thing will affect, you know, hear, and that means you give the judgment in default of hearing the other side. So the court can say one, whether the applicant, the person when they ask now, may they set the judgment aside, whether he get good reason for being absent at the hearing, whether he get any good reason when you not take the court when they hear this matter. What will be reason when say no hear the matter, he no come? That I one. Also, aside from the fact whether he has shown that there was a good reason for his delay in bringing the application. So whether you know when you now say, oh, I hear now, just a hear now I hear now bring the application. So one, whether you get reason for say you know come. Secondly, also whether you get reason for delay in bringing your application. Say for example now you can't say, oh, as at the time when they do this case I know here. After they don't give the judgment, you know, still here, and then which time you take bring the application, you act quick And then also, thirdly, whether the other person will get the judgment and the respondent will not be prejudiced or embarrassed if the order for relief is made. Whether it no go embarrass the person, say, okay, now we set aside this order, whether it go embarrass them, or if you make this order for relief, or whether the applicant case was manifestly unstoppable. So whether this case, so as it be, if you look at if they say, you don't get hard to go to stop her before, or whether the applicant conduct throughout the proceedings is deserving of sympathetic consideration. So whether all true when they do this case, the person when bring this application, so in behavior show say truly you suppose sorry for him, say no, this person no it will say no, so all this now the condition when the Supreme Court, apart from those conditions, it now say, okay, Judge, when they grant those conditions, may you look this thing, so look the applicant, look at whether in the lie, whether a quick come, would it be reason why not take their way of the case, So now, make we look whether all of these issues where we don't talk so, whether it affect the judgment of the NDC, the case for NDC, whether they obtain them by default or whether that judgment they suppose set them aside. Make we now look whether all the reasons, mind you, I don't give you reasons, non-service, and in looking at the other states, whether the judgment now when the court set aside, looking at the parameters of the law, whether the court truly act well. So make we look the judgment now, that judgment. So this now the parties. On the 26th of June, here now they delivered that judgment, Justice Dashe. So this is now the party, Barrister Takori Mohammed Sani, Barrister Ikenna Ikenga, Honorable Abdul Mumuni Oware, Abdul Salam, these are the plaintiff. Then INEC, these are the people who bring the case originally come court to ask court to register NDC. Then this Barrister Emmanuel Uzuuru, maybe Protem National Legal Advisor of Peace Movement Party. Now be the person now when can go court, say, court, I beg, give me order to everything where you don't do before. I beg, set them aside, now go court. So what did the court can look? The court, what did be this order? The order be say, an order of this honorable court extending time within which the party affected may apply to set aside the judgment delivered on the 10th day of December 2025. So that means the judgment they delivered on the 10th day of 2025. So when they bring this application, they bring the application in May 2026. They deliver the judgment December 10th. They bring the application May 2026. So if you look at now, you don't see I'm saying the time when the man sit down, take look. Okay. So make we look what will be the reason. So the judge can talk say that first and foremost, the record of relief revealed that the substantive suit was commenced by originating summons where the plaintiff challenged the decision of INEC refusing to register NDC as a political party. The plaintiff, which is the NDC, now contend say they don't fulfill all the condition of INEC of section 222 of the Constitution. INEC oppose the suit, say on the ground which is related to the proposed logo and symbol submitted by the plaintiff. INEC for that case that time talk say the logo when these people submit say no, this logo resemble another person logo, so we no go fit up register them. The people can't go court. The court now can say I'm now and they as part of their respective application for registration as political. That's okay. So now INEC now say no, we no go agree. They can't go court. Court now can say no, INEC, you need to register them. You need to register them. So now these people now can't go court, say no, this logo where these people use, it resemble our logo. So the judge can't say, he don't consider paragraph 14 and 15 of INEC affidavit, when INEC talks, say, the logo, when this movement party submit, he also resemble the logo when NDC submit. NDC logo, NDC, the movement, what be their name, submit their own application in 2015. NDC submit their own in 2017. So the judge then can say, for this new application, that means INEC don't agree, say the two logo resemble. But you forget also, let me come here. For that main case, the main case initially, make you the same. The judge talks, say the party waiting INEC make INEC no originally register them. INEC say their logo now make them no register them. So that means the issue of logo, they don't consider them for that main case. So bringing up the issue of logo here again now, the judge don't consider them now. So not be new issue. In my opinion, not be new issue, because for the fact of the case, before the judge give that first order, in the first consider the counter affidavit of INEC, say these people logo now make us no register them. Now when somebody come now say that logo resemble our own logo, so but meanwhile we don't submit our, you can say and the logo resemble their logo, and so because of that, well, you don't consider that logo before INEC don't talk. So that's why you know consider that. Assuming say okay, maybe now talk say okay, maybe because that time the judge consider them because nobody talks say the logo na their own. So INEC just talk say but INEC that time don't talk say this logo they conflict with another logo when they application. Why the judge that time no grant order to these people, say go bring those people come, but also INEC okay bring the two logo make I compare. INEC say their logo they conflict, but you went ahead and you granted them order for registration. That are one. Then secondly, these are the body of the judgment will not be made to come. So secondly, the order, like we talk, this order, the judge, this motion was the affidavits, the application, the judgment was delivered on the 10th of December 2025. Now they delivered the judgment. Then the motion, the application where they filed the application by motion dated on the 4th of May 2026 and filed on the 5th of May 2026. So if somebody you give judgment, as a judge you give judgment on the 10th of December, and then between 10th of December, January, February, March, April, now May 5th, the person can realize, say, they don't give judgment against us. So that from that condition when Supreme Court give, the person acts timelessly, where you go say, oh, yes, he act quick. And then also, if you go to the body of the judgment, the judge can talk, say, in the affidavit that the respondent, the applicant, talk, say they know they aware of the case, or they know they aware of that judgment until sometimes in April, that they are aware of this judgment of December. Now April, now they are aware of that judgment, that the present procedure as application filed by the party to set aside the judgment, and that they became aware of that judgment somewhere in the body of the judgment, that they became aware of it in April. Now April they aware of them. If you dey Nigeria since December and you dey diligent, you don't know say court don't give NDC judgment to register party and their party logo resemble your own. January you don't know, February you don't know, March you don't know, now April you can't know. You sure say you dey Nigeria? You sure say you dey diligent when the court go sorry for you? sometimes when our court they give judgment, even though this one not be another class be this, I just event. When our court may they not look say all of us the fool. The court now say, having carefully considered the motion filed by the applicant and exhibit before the court, the applicable constitutional relevant provision, I am satisfied that the applicant has established that it possesses a direct legal recognizable interest in the subject matter. But even if it possesses direct legal recognizable interest, I am further satisfied the applicant was not afforded an opportunity to participate in the proceeding whose outcome was capable of affecting its asserted interest, and that the peculiar circumstances of this case require fair hearing. How do you now say, okay, that you are satisfied that the man they not give an opportunity to hear his own side of the case, and so because of that the application succeed, the judgment you delivered, you set it aside, and you shall revert to the stage, and that the parties at liberty to take necessary step. And so what this clearly had done is that at the end of the day now, after you don't give order, all the issues you are considering now, you don't consider them before. The time the affidavit say I dey aware in April also no show say the person they diligent. And also lastly, remember we consider say whether the respondent go dey prejudice. The party don't collect money, they don't sell form. You sit down, you watch them sell form, they collect money, they do everything, and then the court can say no, you act timelessly after 5 months, before you come. December to January 1, January to February 2, February to March 3, March to April 4, April to May 5th, 5 months. After 5 months, you now say now you come that time, now you wake up and the court help you when you dey sleep. After people don't collect money, people don't use that money, the court no look at the public policy. You remember in Umaru and INEC, after that 2003 election, the court after 2007 election, the Justice Mekitobi of the Supreme Court say, even though we notice irregularity in the national election, but because of public policy, if we nullify this election, that means it will affect a lot of things, the money to do everything again, and the money we don't spend for that, we will allow this mistake. Now, when you nullify or you reverse that decision, all the money for registration and everything, you don't think you allow the party, people acted on it, you don't think all of those things, and then somebody went sit down in own, they sleep, just suddenly wake up 5 months later, and we say equity aids the vigilant and not the indolent. Court now they aid somebody when they indolent, and court they give decision when it be say at the end of the day that decision will go affect so many people. After you don't give the first decision, the court no look all of those things, and then court now they help the person. Say court all the laid down criteria where Supreme Court put say you must look, you don't look all those ones, and then somebody will come because of your party leaning, you go to support them. I don't blame anybody, because these are the problem when they happen. When you do cash and carry political party or chanja market, buying and selling political party. If I say this consistently, Obi had no business leaving Labour Party. If to say he stay Labour Party, groom Labour Party, all this is organic followership, enter Labour Party and register the own Labour Party. If I know they get all this attitude of then you can't go do cash and carry, or the way one article day, so cash and carry, buying and selling, a Labour Party, a political party like say a motor where you go use, when you don't use them again, you discard them.